This is News 12 Law Call.
Hi there, how are you? Welcome to News 12 Law Call. I'm Neil Gordon. Just wondering if it'll be similar this holiday season. Will you be invited to go out to parties and such due to the COVID pandemic? Well, we have on a pair of attorneys from the Hawk Law Group to examine DUIs and the effect this time of year is having on us in the legal system. With Sean Merzalak, we have Tiana Bias. How are both of you tonight?
Doing great, Neil. How are you doing?
Really good, really good. Tiana, just wondering, I'm just assuming since March, have there been less DUI cases? Or Sean, if you want to jump in, less DUI cases come across your desks?
There's been a combination of both. Obviously, with the social distancing guidelines in place, more people are staying home than we've seen previously before March. So that leads to less DUIs. However, there are some people who are still going out and enjoying themselves. We do hope that they will drink responsibly, but for those who have found themselves in situations involving law enforcement, they have certainly contacted our firm for help.
Sounds good. Sean, Scott has a question for you right off the bat. I guess preventative, maybe this hadn't happened yet, but he's wondered if he gets pulled over for drunk driving. Do you think it's good advice to refuse to take the breathalyzer test? Apparently, a friend has told Scott that he should take the test, but he's not sure.
Well, that's an excellent question, Neil, but always my first piece of advice is going to be to not drink and drive when you're impaired. Obviously, you don't want to place you in danger of being harmed or of harming someone else or of getting into these legal situations with being arrested for DUI. However, if you've had a couple drinks, you do happen to get pulled over while you're driving, it's never a good idea to make evidence against yourself. It's never a good idea to do the standardized field sobriety testing, to, follow the officer's pen, walk the line. Those are all tests that in a heightened state of anxiety, plus with, maybe some alcohol involved, are just going to provide, a lot of necessary evidence for them to convict you of being a less safe driver because of alcohol. In terms of the breathalyzer, it's never going to be a good idea normally to provide a breath sample or any type of sample if it's going to be incriminating evidence against you. Just recently in 2017, actually, well, maybe not too recently anymore, but the Georgia Supreme Court changed our law and said that, they could no longer hold you refusing to give a breathalyzer sample against you and use it in your trial. Prior to that, they would, the prosecutors were able to use your refusal for giving a breath sample against you to basically try and convince a jury or a judge that the person didn't give a breath sample, therefore they had to have been under the influence of alcohol. So probably never a good idea.
No, you're right, but I'm wondering what the laws are like. If you don't consent to a breathalyzer, can the officer take your license?
Yes, and that is likely to happen either way. There's something in Georgia called administrative license suspension. Number one, if you refuse to take the state administered chemical test, and that can be a breath, blood, urine, any other bodily substance that they designate, your license can be suspended. Then again, if you do submit to the state test and you test above 0.08, the legal alcohol limit, then also your license can be suspended administratively. And that's all separate from the criminal charges of DUI. So if you get, it's a lot of intricate situations that we have to examine. If you get in that kind of a situation, you definitely need to call someone, a criminal lawyer who specializes in criminal defense and DUI defense specifically to address those issues and go over your avenues with you.
Tiana, let's go a step further. Let's say you're in court and Mark wants to know if you go ahead and you do plead guilty to a DUI. Again, back to the license issue, will the judge still let you be able to drive to go to your regular job each day?
I would tell Mark that while every judge is different, typically we do not see judges suspend someone's license when they plead guilty to a DUI. However, the Department of Driver Services will automatically suspend his license upon a guilty plea to a DUI. but he can receive a limited use permit, which would allow him to drive back and forth to work and school and other areas that are covered by that limited use permit. So it doesn't mean that he won't be able to drive at all.
Okay. Sean, we have an interesting question from Dave, who was very relaxed when he sent in this question, apparently. And he's not from Colorado. He says he doesn't drink, but he likes to smoke a little weed sometimes. And he's wondered if he gets pulled over, Sean, and they give him a blood test and the marijuana does show up, would they arrest him for DUI, even if he had not smoked that particular day?
That's a great question as well, and it just depends. What we're going to be looking at from an officer's point of view is, why would the officer be testing the individual in the first place? To prove a DUI, an officer is normally looking to be able to prove that a person is a less safe driver because they're under the influence of alcohol, drugs, marijuana, some type of intoxicant. So, just because you get pulled over for going 65 and a 55, the officer is not going to have probable cause to ask you to take a blood test, and we don't live in that kind of a system. But as far as the law goes, for DUI, it's against the law to have any marijuana or any controlled substance in your system, especially any controlled substance that's illegal, while you're operating a motor vehicle. And that includes metabolites. When we're talking about marijuana, we always hear the phrasing or terminology that marijuana can stay in your system up to 30 days. Well, when they're testing your blood at the Georgia Bureau of Investigation Crime Lab, they're testing for marijuana, which is THC in your blood, as well as THC metabolites, which is what THC breaks down to in your blood. Both having THC in your blood, which would indicate active use, and having THC metabolites in your blood is against the law in Georgia if you're operating a motor vehicle. So by the law, it's one way. We have to look at the actual evidence in each individual case in order to try and determine whether or not a prosecutor is going to be able to determine or persuade a jury or judge that this person was actually impaired. So, if down the road we get the blood results and there's a small amount of THC metabolites in the blood system, it's a lot easier to persuade a prosecutor or a jury or judge that, this is from prior use, of using marijuana. There's no active THC in the person's system. So therefore they could not have been impaired while driving because of THC. Okay.
Appreciate the explanation. And yours truly lives in a neighborhood with golf carts, with kids driving all over the place. Sometimes there's some danger with accidents, but I never heard about this one. Sharon with a question about golf carts and going a little bit too far. Stick around. You're watching News 12 Law Call DUI edition. We'll be back in a few minutes.
Welcome back to News 12 Law Call with award-winning broadcaster Neil Gordon. And from the Hawk Law Group, attorney Vic Hawk, with more than 30 years experience and millions of dollars awarded to his clients. Attorney Reed Sanders, born and raised in Thompson and known for his strong courtroom skills. With criminal law, former police officer, now lawyer Sean Merzlach. And with South Carolina injury law, trial attorney Chase Hawk. Plus guest attorneys from across the CSRA. Your rights, your calls, live. News 12 Law Call.
Welcome back to News 12 Law Call. I guess you could say the holiday edition with the threat of DUIs across the CSRA, a lot of parties and such. And we want to get you prepared to understand what the law is and what your rights are as well if you happen to get stopped. And we have a pair of attorneys from the Hawk Law Group to help walk us through, including Tiana Bias as well as Sean Merzlach. And both of you, like I mentioned before, I hadn't heard of this one. This is a question from Sharon. Tiana, she lives in a golf course neighborhood. We often use the golf carts to get around the neighborhood, but last week after pulling into our own driveway, A police officer pulled up and gave her husband a DUI ticket. I mean, can you get charged with driving under the influence, Tiana, if you're just on a golf cart? You know, they only go about 20 miles an hour. You're near your own driveway. What gives here?
Well, I'd first tell Sharon that unfortunately he can receive her husband can receive a ticket for DUI. Neil, like you said, golf carts can go upwards of 20 miles per hour, and DUI laws cover any moving vehicle, including golf carts. There are some traffic violations that may not be cited on private property, but unfortunately for Sharon's husband, DUI does not fall under that exception. So he does need to contact the criminal defense attorney so that they can try to negotiate a resolution that would benefit him and his family.
Just a little off the subject, do you guys ever get calls about accidents with golf carts and whose parents responsible for kids? I mean, does that ever even enter in?
We do, Neil, quite a bit, and just of recently, we've had several cases that involved DUI people that were charged with DUI on golf carts.
Wow. And I'm guessing, even though this isn't the right season, same thing if you're out on Lake Thurman in the nice weather, right? Boating as well.
That's correct.
Same deal. Okay. All right. Here's an interesting question, Sean, from TC. He's trying to get his life together, and he's going into rehab for a drug problem. When he comes out, and if he's kind of been, you know, it's understood that he's clean, will it keep any of those charges like a DUI off his record? Like, does that count for good behavior, for lack of better words?
It counts for good behavior in my book, absolutely. And it's definitely going to be good for his long-term success in life. Unfortunately, there's no actual law in Georgia that allows, you know, for just because a person has attended some type of rehabilitation program for a DUI to be dismissed or cleaned off their record. We give a lot of advice to our clients depending on their situation. And sometimes it is going to either AA meetings or going into an outpatient drug or substance abuse or alcohol rehabilitation program, or an inpatient treatment program, depending on their needs. What we can use that for is later on down the road, once we've evaluated the case, we've determined, you know, whether or not a case is a trial or not. Using that, you know, as mitigation with the prosecutor as well as the judge to get them a better result for their case, whether it be a better sentence. Sometimes we can have portions of the DUI sentence not imposed because a person has already done something. Things like clinical evaluations, risk reduction courses that are usually mandatory parts of a sentence. Sometimes the judge is more likely to allow that inpatient or outpatient rehabilitation program to count for that. But as far as just going to a rehab and it making the DUI go away, that's not likely to happen.
Okay, fair enough. Tiana, a question from Bradley, who is now a native son, just moving to the CSRA, but he's got an old DUI conviction from living in another state. Will it count against him if he were to get another DUI in Georgia? Or does it go state by state? So if he's never had an issue in Georgia and he gets one, that just counts as one, or does it count as two?
Well, what Bradley needs to remember in this case is that you can't just bounce around from state to state hoping that you'll get a clean slate each time. That would be nice if people had that opportunity, but once your case gets sent to a prosecutor's office, or even when you're pulled over by law enforcement, they typically have access to your criminal history across all 50 states. So they can and likely will hold those previous convictions against you, even if they happen outside of the state of Georgia. And they typically will focus on those that have happened within the last 10 years or so. And they hold different consequences depending on how recently they were and how many you've had within a certain time span.
Okay. Barry with a question for you, Sean. He's got a DUI charge and a conviction from when he was in college. A friend told him that after a certain number of years, the charge would no longer be on his record. Is that true in Georgia, almost like a statute of limitations? Does it eventually get removed?
Unfortunately, that's not true, Neil. I tell people all the time that a criminal history is just like a shadow. It's always going to follow you. There's some certain, sentencing options that we can do on certain cases that allow for, a conviction to never occur and a case to be discharged without it being on your criminal record. But that's not normally applicable by statute to DUI. Like the Georgia First Offenders Program specifically does not apply to DUI offenses. So if he's already got a DUI conviction on his record, it's going to remain there. I'm not aware of any, type of law that would allow us to remove that or expunge that. But obviously, the longer time period that goes in between the time that he had this offense and the time that someone sees it on his record, the better it is for him. I don't think an employer, 10, 15, 20 years down the road that sees a DUI offense on a person's record is going to really be that big of a deal.
Well, when we come back, we'll answer the question, how many DUIs are too many for you to lose your driving privileges? That's a question from Roshonda. We will take that question and share it with the attorneys after we pay the bills. You're watching News 12 Law Call DUI. Well, thanks so much to attorneys Tiana Bias and Sean Merzalak for appearing on behalf of the Hawk Law Group. The headquarters are on Telfair Street in Augusta. The website, hawklawgroup.com. You can set an appointment there, do a live chat. Hey, if you get pulled over and you're top of mind, just remember all fours. You can dial 706 all fours. And Sean, you've been defending folks with DUI charges for many years. Just wondering, is there one that sticks out to you, someone who called and you kind of walked him through the system and hopefully had a good result?
We've had a number of good results and a number of cases that, come to mind. And normally it's the cases where people have had multiple DUIs and they finally realize that we talk with them and we get them to realize that, they have an alcohol dependency disorder that we need to attack in order for them to be successful in life. Otherwise, these things are just going to keep happening. One in particular, gentleman came to me with 2 DUIs. One involved his child actually being in the car with him. No one was hurt or anything like that, thankfully. But he had had 4 or 5 DUIs in the past. We realized, and he finally came to the realization that he needed some help. We were able to get him into a inpatient treatment program where he spent, I think, 6 to 7 months before coming back out and enrolling in aftercare program, going to AA all the time, and really changed his life. Looked like a different person when I saw him again. We were able to postpone the case through these 2 different court systems until he was done with all of that. And then it led to, the judges being so impressed with him and the prosecutors that we got a really excellent result for his case, including one of them being reduced to reckless driving and not having all these mandatory jail time things, stuff of that nature.
Well, hard work sometimes pays off, and second chances, third or fourth chances. That's wonderful. And Tiana, to that point, as it relates to driving, Roshonda says she works with a gentleman who she also believes has at least 3 DUI convictions. And she's simply amazed how the man can get back in a car and drive. Are you aware of typically how many DUIs our judges in Georgia or South Carolina may allow before they just take the keys?
Yes. So what Roshonda needs to remember in regards to her coworker is that not every DUI arrest results in a conviction for DUI. Even if he's had 3 previous arrests, he may have pled those down with an attorney to reckless driving or some other sentence that doesn't have the same repercussions that a DUI may have on your license. As far as the court system goes, in the state of Georgia, they'll look at how many DUIs you've had in the last 10 years. As far as the Department of Driver Services, they'll focus on the last 5 years. And after that third DUI, you're going to start looking at some very different sentencing ranges and being charged in superior court rather than on the lower level courts, like a misdemeanor DUI would typically be sentenced.
Okay. Julie's got a question for you, Sean, before we scoot her. Grandpa takes medication to control mild dementia. Would he be at a risk of a DUI charge if he's pulled over while on that medication? She thinks it would suppose them requiring them to take his blood, which she has a problem with. So explain how it all works.
Well, it kind of goes back to the question we had earlier about the marijuana. I don't know what type of medication people take for dementia, whether that causes any issues that could be seen as impairment or not. If it was some type of a drug that causes drowsiness, sleepiness, or impairment conditions that makes you a less safe driver, well, then obviously he doesn't need to be driving while he's taking that. If he is, pulled over, is taking that medication, and police have probable cause to believe that he is DUI, they could ask to take his blood. And, what they have to prove is that he's a less safe driver. The actual standard is that he's incapable of driving legally or incapable of driving safely when he's on prescription medication. But that pretty much means that he's a less safe driver.
Deanna, real quick, parties are coming up. If you have too much to drink, who's going to be responsible? You or the person throwing the party at the home or the local hotel bar throwing a party?
If you're an adult over the age of 21, then you're going to be responsible for your own consumption of alcohol. The only way that the person who provides you with the alcohol will be responsible is if you are a minor and they should have known or should have ID'd you. And it's going to be a strict liability issue. Whether or not they knew you were under 21 is irrelevant. So as long as you're over 21, you're going to be responsible for yourself. If you're under the age of 21, and the person who provided you with alcohol would be responsible, most likely.
Real good. We'll have to leave it there. And kind of what Sean said earlier about drinking and driving. Please don't. And 2 words, Lyft and Uber and taxi.
It's too easy not to. That's right.
Thank you. Appreciate all your insight. Hopefully we helped some folks tonight. We will see you next time, and we hope everyone has a safe holiday season. Take care.
Y'all have a good night.